Hi, my name is Joe Lento. I'm an estate planning attorney and the owner of Perennial Estate Planning. Today, I'm going to teach you as much as I can about estate planning in less than 30 minutes. However, before I begin, I want to give you two important disclosures. Number one, I am only licensed in Massachusetts and New Hampshire, so some of the terminology I use today may be specific to those two states. And number two, any information I provide today should not be taken as legal advice. Please speak with your local estate planning counsel before starting your own estate plan. Overview. This video is divided into three parts. In part one, I'm going to walk you through the fundamentals of estate planning. What is estate planning? What are the common objectives or concerns my clients have? And what are the core documents typically found in an estate plan? In part two, I'm going to walk you through the documents in further detail and also introduce client-specific scenarios or issues that you may find applicable to your own family situation. And in part three, I'm going to walk you through the logistics of estate planning. How long does the process typically take? How much does an estate plan usually cost? And how should I prepare for the initial estate planning meeting? With that being said, let's get started.
Part 1. Fundamentals.
What is estate planning? Estate planning is about protecting your family's future. A lot of people may think, oh, I'm married or I have adult children, so my spouse or my kids, they'll just take care of whatever happens to me. But the reality is, if you don't have it in writing and it's not legally binding, meaning it's not properly notarized or witnessed depending on your state law, then it's not your family, but it's the government that's the first decision on what happens to you and to your stuff. So if you want control over your life and your property, then you want an estate plan. What are the common concerns or objectives of an estate plan? So when I meet with clients, they usually have one or more of the following three concerns. Number one, how do I protect my children's inheritance? If you don't have children, this may be protecting the inheritance of your nieces or nephews, close friends, or other family members. Number two, how do I avoid probate court and make things as easy as possible for my family? And number three, how do I avoid or minimize taxes? I don't want my money going to the government. And fortunately, with a well-drafted estate plan with the proper documents in place, you can generally achieve all three objectives. What are the four core documents of estate planning? So virtually all of my clients have the following four documents. Number one, a revocable living trust. Revocable means you can change or amend the trust at any point in time, so long as you are of sound mind. So in effect, you're in full control over the trust and the assets placed in trust during your lifetime. Number two is a pour over will, like pouring a glass of water. And it's called a pour over will because it pours your assets into your trust in the event anything goes through your estate. Number three is called a financial power of attorney, sometimes referred to as a durable power of attorney. And this document authorizes someone to make financial decisions on your behalf. And number four is called a healthcare power of attorney, also known as a healthcare proxy. This allows a person to make medical decisions on your behalf in the event that you become incapacitated. And those are the four core documents that most clients have in their estate plan. What is probate? If you've ever dealt with probate before or know someone who has, then I'm sure you're already shaking your head. At best, it's an inconvenience for your family, and at worst, it's an absolute nightmare. The gist of it is, if any assets pass through your estate upon your death, then your family will need to petition the court in order to inherit those assets, but must go through a full public court process before doing so, and that usually takes most clients up to a year to complete. Just to give you one story on that, I met with a client 7 years ago. He said, Joe, the reason I'm here doing my estate plan with you today is because my father had a piece of real estate, he never did anything with it, and now me and my family are fighting over it in probate court. And the worst part of that is, I met with that same client a year ago, and they're still fighting over it in probate litigation. Now, I don't have all the details, but I can almost guarantee the legal fees on that piece of property in that probate case probably far outweigh whatever that client will ultimately receive from that property when it's sold. So the gist of the story is, you do not want to go through probate court, and you certainly don't want your family going through it after you're gone. How do I avoid probate court? So now that you know you want to avoid probate court and make sure your family never has to deal with it, the next logical question is, how do you avoid it? And the simplest solution for most clients is to create a revocable living trust, which you may remember is the first document I mentioned in the four core documents that most of my clients have. A revocable living trust is essentially a family agreement. It consists of three roles. You have the grantor or the trust maker, which is you, the creator of the trust, adding your assets inside of it. Then you have what's called the trustee or the manager of the trust, which once again is you during your lifetime, but becomes someone else after you die, what we call the successor trustee. And then you have the beneficiary, which once again, that's you during your lifetime, but after you pass away, you can name your spouse or children or other family members or close friends as the beneficiaries. Now you may be thinking, wait a second, I have a will, and I thought the whole point of me getting a will was to avoid probate court, but that's actually incorrect. In fact, a will is designed specifically for the probate court process. It's like an instruction manual to the judge and to your executor as to what you want to have happen. So if you want to avoid probate court, the will is not the answer. You need a trust. But then the question becomes, if I have a trust, then why would I need a will? And for most clients, they don't. But we typically still draft what's called a pour over will because we want to make sure that if you don't put something in the trust before you pass away, or you don't have an asset routed to the trust to avoid the probate court process, then the will is still a great catch-all or safety net to pour your assets back into the trust. That's why we call it a pour over will.
Part 2. Details and scenarios.
Things to consider when drafting your financial power of attorney. So your financial power of attorney, also known as a durable power of attorney, is a document that authorizes someone else to act on your behalf with respect to financial decision making. So for example, paying your bills for you, filing your tax returns, or even accessing bank or retirement accounts on your behalf. For married couples, they typically name their spouse as their agent, and if they have adult children, they'll name those people as their backup agents. But if you are not married or if you don't have adult children, then you may name a parent, a sibling, or perhaps an adult niece or a nephew or other close family member. Keep in mind that when you're drafting the financial power of attorney, you can make it effective immediately or a springing power of attorney. So what that means is, if it's effective immediately, as soon as you sign that document, if the person named has access to it, they can do all of the powers you specify in the document. However, if it's a springing power of attorney, then that means it's only activated in the event you are deemed incapacitated. Usually a doctor would certify your incapacity. And until that point in time, that agent could not act on your behalf. Now in practice, most powers of attorney are effective immediately for financial powers. However, if you are naming someone who is not a spouse or an adult child, you may want to make it springing power, meaning only effective if a doctor certifies your incapacity. And that's just a simple safeguard so other people can't access your financial accounts and that type of thing. Another thing to keep in mind, if you name more than one person to serve simultaneously as your financial power of attorney, we call that co-agents, then you should specify whether they have to act jointly or whether they can act independently. That's very important for when they're dealing with banks or other third parties, because if you don't specify it, then they'll probably make it a hassle for them to act on your behalf, which defeats the purpose of the document, which is to allow someone to immediately act for you if you become incapacitated. Things to consider when drafting your healthcare power of attorney. So unlike your financial power of attorney, your healthcare power of attorney generally only comes into play if you are in fact deemed incapacitated. What that means is no one can supersede your medical decision making if you are of sound mind. With that being said, a couple of things to consider are, number one, when you are naming an agent under your healthcare power of attorney, you should generally only name one person at a time. Some states like Massachusetts require this, but other states like New Hampshire give you an option. If you name co-agents, you need to be extremely clear on what happens if they disagree. Otherwise, it's going to create a mess for you. Number two, when you're drafting the healthcare power of attorney, some states have a living will or advance directive built inside of the document. This could specify what you want to happen in the event that you are placed on artificial life support or similar situations. Once again, be very clear on what you want to happen. Otherwise, your agent could get into an argument with the other family members. You should also keep in mind that certain states have this legally binding while other states don't. So for example, in Massachusetts in the healthcare proxy, I'll include this language, but just know it's only guidance. It's not actually legally binding on the agent to act in that way. Whereas in states like New Hampshire, the living will actually has legal statutes behind it to make it enforceable. Drafting your trust. When it comes to trust, there's a lot of misleading or just completely inaccurate information available online. So what I'm going to do is I'm going to break down the most common questions clients ask me about trusts, and then from there, give you my recommendations on what you might want to consider when drafting your own trust. Should I have a revocable trust or an irrevocable trust? This is usually the first question clients ask me when they want to meet about setting up a trust. And for most clients, the revocable trust is the best option for them. And once again, the reason for this is because the revocable trust allows you to control the trust during your lifetime. You can change or amend it at any point in time. You can access the assets placed in trust, and you can serve as the trustee of the trust. With that being said, if you go irrevocable trust, what that means is, generally speaking, you can no longer access the assets placed in trust. You can no longer serve as trustee of the trust. And generally speaking, because of the limitations placed on the trust, you cannot use those trust assets for your benefit for the remainder of your lifetime. Now, of course, there are exceptions and carve-outs and escape hatches to irrevocable trust, but generally speaking, you would only use an irrevocable trust if you had an asset that you want to get out of your name, but you also were not comfortable with your kids owning outright. So the most common example of this is an irrevocable trust designed for nursing home protection purposes. And in that situation, the client may put their home in the trust and name an adult child as the trustee of their trust. Other than that, most clients are almost always best suited by doing a revocable trust. If I'm married, should I have a joint trust with my spouse or should we have separate trusts? Believe it or not, some of my clients, when they first meet with me, are not aware they could have a single trust that they share with their spouse. And for younger clients, I generally recommend this approach as a starting point because it's simpler and it's often cheaper to set up than having separate trusts. But with that being said, you may want separate trusts if any of the following three situations apply to you. Number one, blended family scenario. And what I mean by that is if this is your second marriage, or if you or your spouse have children from a different relationship, then you may want separate trusts because if you have a joint trust and your spouse survives you, they may treat your children differently than their own. Number two, estate tax considerations. If you are above the estate tax threshold in your state, or if you're above the federal estate tax threshold, then you may want separate trusts to lock in your estate tax exemption. And number three, liability. If you do not want to share liability with your spouse with regards to business or rental properties or other risks that you perceive you're supposed to have, then you may want separate trusts. Okay, now let's walk through some client scenarios so you have an idea of how your trust can be customized to meet your family's needs. Drafting a trust for minor children. If you have a child who's under age 18 or a child who's just not financially mature yet, then what you can do is name a successor trustee, meaning a person who steps into your shoes after you're gone to manage the money for the benefit of your child until they reach an older age. Some clients do lump sum distributions, meaning at age 25, the child could receive all the money outright, and other clients do what's called staggered distributions, meaning they could give, for example, 1/3 at age 25, half of the remainder at age 30, and all of the remainder at age 35. But regardless of when the child is to receive all the money outright, in the meantime, the trustee can spend it for their benefit for health, education, maintenance, or support reasons. We call this the HEM standard. So in other words, the child can still benefit from the trust assets while it's held in trust, but it's the trustee making the decisions, not the child in terms of what it's spent on. And then when the child hits the age that you specify, they can receive the money outright. What happens if I have multiple minor children at the time of my death? How should I draft my trust then? If you have more than one child under the age of final distribution, whether it's age 25, 30, or 35, at the time of your death, then you need to decide whether you'll have a common pot trust, meaning a single trust for the benefit of all your children until the youngest reaches a certain age, or separate shares or separate subtrusts for each child upon your death. And I almost always recommend doing the separate share or separate subtrusts for the benefit of each child upon your death. And the reason for that is twofold. First, it makes the trustee's job so much easier. They don't have to worry about spending too much money on one child versus another because their share is already earmarked upon your death. And number two, the older children don't have to wait for the younger children to receive their share outright. Each of their subtrusts operates independent of one another. What happens if I have a child or a beneficiary named in the trust who is disabled or has special needs and is currently receiving or may be receiving government benefits in the future? How do I leave them money without interfering with those government benefits? So there's a special category of trust called supplemental needs trust, also known as special needs trust, that are designed for this exact purpose. And the basic idea is, rather than giving the money outright to the beneficiary, it's held in further trust, usually for their lifetime, and under the management of another trustee. And the trustee is directed in general terms to supplement but not supplant their lifestyle. And as long as the trust is drafted correctly, it generally does not interfere with government benefits. What happens if after I'm gone and I've left all my money to my kids, one of them then gets divorced or sued or has creditor problems? Can I still protect their share of inheritance then? And the answer is generally yes, but you'll probably notice a theme here in that the only way you can really do that is you would not leave the money to them outright, but instead would leave it in trust for their benefit. And by doing so, you can minimize the risks associated with those type of scenarios. But also keep in mind that when you do this type of trust, it adds a whole layer of complexity that some clients don't want to deal with. And also, you're now adding restrictions on your child to make sure that their creditors are also restricted from those assets. So please keep that in mind before you draft one of these types of trusts. What happens if after I'm gone, I want to provide for a boyfriend, girlfriend, significant other, but also make sure that there's money left aside for my kids after both me and my significant other are gone? How should I set up a trust? So this is a common scenario that happens in blended families, meaning a second marriage or a situation where you have kids from different relationships. And the way we typically do this is we might include what's called a right of occupancy provision inside the trust, meaning after you're gone, if the home is held in trust, it allows the significant other to continue living there free of rent or under the terms you specify. But after they're gone, or if they decide to leave the home or no longer use it as their primary residence, it automatically goes or is sold for the benefit of your children. And by having it in trust this way, you can make sure that your significant other doesn't alter the arrangements of that asset after you're gone. What happens if I go to a nursing home? How do I protect my assets then? So this is a highly controversial issue, and attorneys will differ in their approach, but the general idea is, or at least one solution is, you create an irrevocable trust, you place your asset in that trust, and as long as the trust is set up correctly, and you get beyond the 5-year look-back period, then that asset is generally protected for nursing home purposes. But keep in mind, these types of trusts will vary depending on what state you live in. In other words, certain provisions that may be allowed in Massachusetts are not allowed in New Hampshire. Also keep in mind, you cannot be the trustee of this trust, and you cannot, under any circumstances, have access to the principal held in trust. So just to give you an example on that, let's say you set up the trust, you do it correctly, you put your home in that trust. The trustee may be able to sell that home to allow you to downsize and buy a different home in the name of the trust, which you could then still live in, but you cannot, under any circumstances, receive the sale proceeds from that sale for your own benefit during your lifetime. So when you set up a nursing home protection trust, you are effectively giving away the asset for the rest of your life. Trust funding. Now that you understand the basics of what a trust is and how there are different variations of trusts, you should be aware that even after your trust is created, there's still one more step, and it's called trust funding, or placing your assets inside the trust. If you do not put your property inside your trust or direct it to your trust after your passing, then it could go through probate court. You may remember I told you the story about a client who's been in probate litigation for 7 years with their siblings over the father's piece of real estate. What I didn't tell you is that the father actually had a trust, but he never put the real estate inside the trust, and that's why I went through probate court, and that's why it's currently in litigation. So I cannot be more clear on the fact that you need to make sure that your assets are properly funded into the trust, otherwise all the work you did in creating the trust is for nothing. How do I fund my trust? So depending on what type of assets you have, your trust funding instructions will vary, but generally speaking, it looks something like this. With respect to your real estate, your estate planning attorney will normally draft a deed for you, and the deed will show you transferring the home from yourself individually to you as trustee of your trust, and that's how it avoids probate court. Now, with that being said, if you have property that's located in a state that your attorney is not licensed in, so for example, I'm licensed in New Hampshire but not in Maine, and let's say you have a vacation home in Maine, what will often happen is I'll coordinate with a real estate attorney in Maine to make sure they draft a deed for you, so immediately upon your signing, you'll also be transferring that out-of-state property into your trust. With respect to financial accounts, you have a couple options. For non-retirement accounts, you can do what's called a retitling or a pay on death, POD, or transfer on death designation. A retitling is actually changing the account ownership into the name of the trust, whereas an updated beneficiary designation like a POD or a TOD is simply saying that after your passing, you want that account to automatically go to your trust, and that will still avoid probate court. Now, with respect to retirement accounts, if you are married, you'll probably still want your spouse as your primary beneficiary, but make sure you keep the trust as the second or contingent beneficiary. With respect to life insurance, it's the same idea. Make sure the death beneficiary is named as your trust. The only exception being if you have an irrevocable life insurance trust, and in that case, you'll want the policy actually owned by the trust. With respect to your vehicles, it varies by state. In New Hampshire, if your vehicle is paid off, the common practice is to transfer into the trust, whereas in states like Massachusetts, that could cause complications with your insurance, so clients don't always transfer their vehicles into their trust. And then with respect to business interests, like an LLC or corporation, your estate planning attorney will often draft an assignment of interest, which transfers the business interest into the trust. In terms of other tangible personal property, like things around your house, artwork, furniture, jewelry, what usually happens is the estate planning attorney will draft what's called a general assignment of interest, and that will transfer all of those types of assets into your trust. But please confirm with your attorney before making that assumption.
Part 3. Logistics and other frequently asked questions.
How long does the estate planning process usually take? So for me personally, I like to aim for 4 weeks, meaning I want to have your signing done within 4 weeks of the first day I meet with you. However, for some clients, that's not feasible. Also keep in mind, a large part of the process is dependent on how long it takes you to review the documents and get back to your attorney with questions or changes. So if you sit on your documents for weeks, then it's only going to prolong the process. Also keep in mind, of course, there are emergencies. So for example, sometimes I'll have clients call me up and they say, Joe, I just found out I have a heart condition. I have surgery next week. Can you get the documents done in time? And of course, we'll adjust to your schedule. I also have some clients who'll book an international trip and then realize weeks before they need to update their estate plan or they don't have an estate plan. And once again, we'll adjust to your schedule. What are the steps involved in the estate planning process? Most attorneys will divide the estate planning process into 5 steps. Step 1 is the initial meeting, where you'll tell your attorney about yourself, your family, and any concerns you may have. Step 2 is called the design meeting, where the attorney will walk you through your options and help you structure your trust. Most attorneys will combine the initial meeting and the design meeting into the same meeting. However, some clients prefer to separate the two, and that's completely fine. Step 3 is the drafting phase, where you'll work with the attorney to review the documents, ask questions, and update the documents accordingly. Step 4 is the signing, where you'll actually execute the documents. And step 5 is the trust funding phase, where you'll make sure your assets are either going into the trust or set up to go to the trust upon your death. What do I need to prepare for the initial meeting? This will vary depending on which attorney or which firm you're working with. Some attorneys require you to fill out a questionnaire before you meet with them. Other attorneys like myself will say, just show up with your questions or concerns and I'll take it from there. The reason why I currently take that latter approach is I find it's more convenient for the client and it reduces friction in the process. However, I completely understand the merits of the questionnaire, and I think for certain clients, it can definitely lead to a more productive conversation. With that being said, if you're curious what I usually ask in the initial meeting, it's usually the following 3 things. Number 1, tell me about yourself and your family. Number 2, at a high level, walk me through your assets and your liabilities. What do you own and what do you owe? And number 3, do you know who you want to appoint for the key roles in your estate plan? Who would be your successor trustee, your financial power of attorney, your healthcare power of attorney, and who would be your backups? Now, I don't expect you to have answers to all these questions necessarily, but at least it gets the ball rolling in terms of how I should draft the documents. How much does an estate plan typically cost? So for most clients, the estate plan cost will be somewhere between $2,500 to $7,500. Now, if you have a conventional family situation, meaning it's you, your spouse, you have adult children, you own a single home, you have your retirement accounts and checking and savings accounts, and that's it, and your only real concern is to avoid probate court, then you're going to be at the lower end of that spectrum. However, if you have a complex family situation, complex asset mix, or you want some asset protection features built into your trust, then you're going to be at the higher end of that spectrum. Also keep in mind, if you are part of the 1% that are concerned about federal estate taxes, then your estate plan is going to be much more expensive. those will typically start around $10,000 and quickly add up depending on what type of irrevocable trust you need for your estate plan. How often should I update my estate plan? So the generic answer I tell clients is take a hard look at your documents once every 5 years. And I know a lot of attorneys will disagree with me. They might say, no, that's way too long. Do it like once every 3 years or once every year. But the reality is you're just not going to do that. Once every 5 years should be adequate for most clients. With that being said, I do find most clients tend to do their estate planning in 3 phases. The first one is your startup or basic estate plan phase. You just had your first kid and you just want something in place. The second phase is when you're entering retirement years, maybe you're approaching retirement, your kids are graduating from college or going into college, and you're thinking, we have more wealth, we should probably get a more advanced estate plan done. And then you have your third phase of estate planning, which is, you're much older now, you probably have grandchildren, and you're looking back on your life, and you're thinking about what's really important to you, and that's called your legacy estate plan. However, if you have a major life event in between those phases of your life, then obviously update your estate plan then. But for most clients, in reality, they might update their estate plan once every 15 to 20 years at most. Where should I store my estate planning documents? So back in the day, what used to happen is estate planning attorneys used to vault or keep the originals in their office. And there are definitely some estate planners that still do this. But what happened with this is 2 issues arose. Number one is, what happens if you want to change your estate planning attorney? This can be a little bit awkward. Although the new attorney will probably just supersede the old ones, you probably want the originals in your hand anyway. And number 2, estate planners are humans too, right? So sometimes they die suddenly, or they retire, or they move offices. And even if they maybe try to notify you in all 3 events, they might have an old home address or an old email address, and you don't get notified, so you don't know where your originals are. So just to avoid both those scenarios, what I do is, at your signing, I give you the originals back. I also scan them into my server, so I have signed electronic copies. I email you those copies, so that way you have signed electronic copies, which you can then save on your cloud or on a flash drive. And then what I do is, I make sure your financial advisor has a copy of them, or your CPA or other trusted advisor. And you can also forward the electronic copies to your trusted family members. However, if you decide to give the copies to your family members, be aware that if you decide to change things later on and they notice that change, it could ruffle some feathers. So what some clients do is, with respect to family members, is they might say, hey, here's the contact information for my attorney or my financial advisor. If you can't find my originals or my copy that I've saved on my server, then at least you can reach out to them and get copies. Now, with respect to your physical originals that you now have in your hand, what I would say is, get a document storage safe or a filing cabinet, or put them in your gun safe if you have a big one. Those tend to be the best place to put the documents. If you don't have a safe or a document safe, you can easily get one at Costco's or BJ's or even on Amazon. So that's usually the best way or best practices when it comes to securing your estate planning documents. Congratulations, you got to the end of the video. I'm very impressed. If you have other questions about estate planning, or you'd like to learn more information about what I do, you can visit perennialestateplanning.com. I hope you enjoyed the video, and I hope you have a wonderful day. Thank you for listening.